Sorry.
Yeah. Oh, okay. Then we will do that. It's okay.
Provision of section 134 of the CPC. On the premise of this preliminary point of law alone, my learned brother, in Criminal Anti-Corruption Appeal number E16 of 2022, where the learned judge, dated 7th September 2020, are tainted with defects, namely, and if the answer is in the affirmative, whether the defects are fatal or otherwise. Learned counsel for the first accused, Mr. Enya, Roman 1. Having failed to present a prima facie evidence in support thereof, and having further offended the rule against duplicity, count 1 is dismissed, and all the accused persons are acquitted therefrom, under section 210 of the CPC. Roman 2. Having failed to present prima facie evidence in support thereof, and having further offended the rule against duplicity, count 8 is dismissed, and all the 3 accused persons are acquitted therefrom, under section 210 of the CPC.
It's a long question. We intend to call 4 police officers from the Directorate of Criminal Investigations and other witnesses. 4 police officers. About 15 witnesses. For the first accused? Yes, for the first accused. And to be honest with you, it is in my practice, that's the longest defense I have seen. 15 witnesses.
Sorry.
Yeah. Oh, okay. Then we will do that. It's okay.
Provision of section 134 of the CPC. On the premise of this preliminary point of law alone, my learned brother, in Criminal Anti-Corruption Appeal number E16 of 2022, where the learned judge, dated 7th September 2020, are tainted with defects, namely, and if the answer is in the affirmative, whether the defects are fatal or otherwise. Learned counsel for the first accused, Mr. Enya, dated 7th September 2020, therefore, and having addressed my mind to the holding, rendition, and threshold set by the High Court in paragraphs 21 and 22 of the said judgment, this court is unable to find the charges as framed defective in the context of that rendition of the High Court. Defective on account of ambiguity. However, this court must acknowledge as a matter of fact that there are manifest defects in form, whereas the former, that is a defect in substance, is fatal, a defect in form is otherwise. Further, having deployed the same rendition to the second, third, and fourth issues, this court is also unable to find the charges ambiguous when subjected to that high threshold set by the High Court. Turning to the preliminary point of law, namely duplicity, this court has found no statutory definition of that terminology. And for that reason, the court resorted to secondary sources of law. And in this case, the Black's Law Dictionary, 9th edition, 2009, at page 578 came in handy. It defines duplicity as follows: deceitfulness, semicolon, double dealing, full stop. Number 2, the charging of the same offense in more than one count on an indictment. Number 3, the pleading of 2 or more distinct grounds of complaint or defense for the same issue. In criminal procedure, this takes the form of joining 2 or more offenses in the same count of an indictment. The relevant law is housed in section 1, where there is an effective and sufficient charge of a substantive offense. The addition of a charge of an inchoate offense is highly undesirable. This court finds that none of the charges can be said to have taken the form of either the first or the second cluster of duplicity. However, it seems to this court that the state may not have observed the third facet of duplicity. The Black's Law Dictionary at page 51. In this context, this court finds that the decision to prefer a blend of inchoate offenses set out under counts 1 and 8, which had already suffered a natural death, at least by assertion by preferring the substantive charges, together with their corresponding substantive charges under counts 2, 3, 4, 5, 6, 7, 9, 10, 11, 12, and 13, in a separatist and independent frame, offends the rule of election, resident in the general rule in the Kinyanjui decision. Under the rule of election, the prosecution should have elected to charge either the inchoate offenses separately, the inchoate offenses under counts 1 and 8 to the exclusion of substantive charges under 2, 3, 4, 5, 6, 7, 9, 10, 11, 12, and 13, or the substantive charges under 2, 3, 4, 5, 6, 7, 9, 10, 11, 12, 13 to the exclusion of the inchoate offenses under counts 1 and 8. Alternatively, let out under counts 1 and 8 are duplex. Third, turning to the issue raised by all accused persons that the charges are unfair, illegal, unreasonable, and irrational, this court conceives it to be a question of both law and fact. Unlike the preliminary points of law afore discussed, some evidence is thus required to dispose this question. Although the question is in the nature of a judicial review question, best suited for the High Court sitting in its judicial review jurisdiction, alive to the remit of the jurisdiction of this court as a trial. That will continue.
So we're not married and the proceedings up to today as we go to the next case.
Very well. 7th, 10th, 13th. March